colleagues, dear students, and the trustees of the Vijnaneshwara Pratisthana Trust, Marathur. In fact, they have conducted many workshops on various aspects in law throughout our the state as well. It should be applauded always. Of course, insofar as when I received a call from Mr. Mahadevaya from Pratisthana to deliver a lecture on this aspect, of course, I accepted and got material about the same. But one thing it is very clear, dear friends, as I acknowledge my thoughts in my brochure, that is my to remember always whenever we deal with any matters relating to the law. Firstly, P.V. Khane, history, writing, history of Dharma Shastra, the great our jurist, Dr. Justice Rama Joyce, on legal and constitutional history of India, where I had an occasion to interview during my LLM assignment. Dr. Rama Joyce, he spent more than 5 years with me. Even today I remember it's not merely an interview, it's blessings on me. And of course, if you read anything about the Hindu law, none other than the P.V. Khane or Rama Joyce or anyone, the great English author Main's thoughts on Hindu law we never forget. That's also given input to this the lecture. And lastly, insofar as I've also borrowed certain things from the lecture delivered by Justice Markandeya Khatib at Banaras University relating to the ancient Indian jurisprudence. Because if you read anything about the ancient, you may call it, or it's the history of legal history of India. One way or other, somewhere in the middle of our thoughts, then the earlier the foundation laid by our sages, that is our rishis, and also the nowadays what we say that the advancement in technology. With this, I will begin my lecture on this aspect on ancient Indian jurisprudence. Ancient Indian jurisprudence is a fascinating tapestry woven with the threads of rich cultural, philosophical, and religious traditions. Stretching back to thousands of years, this body of law reflects the evolution of Indian society and its approach to justice, governance, and social order. These are the three important aspects, whether it's ancient or modern, or we may call it as contemporary world today. One must look into the justice, governance, and social order. These are the three aspects. We call it as trimurti, through laws, through legal aspects is concerned. The ancient Indian legal system was not merely a set of rules and regulations, but a comprehensive guide to ethical living, social responsibilities, and the administration of justice. Understanding the ancient Indian jurisprudence requires a deep dive into the historical context, key legal texts, and the socio-political environment of the time. The schools of jurisprudence, there are 4 schools where philosophical school, analytical school, historical school, and lastly the sociological school. Jurisprudence is a philosophy of law. It encompasses the most general aspects of law, differentiating itself from laws dealing with specific subjects. Jurisprudence explores fundamental questions like the nature and purpose of law, its origins, development, and relationship with other social phenomena. Ancient India witnessed significant legal developments, evident in numerous Sanskrit legal treatises. It is believed that the Hindu law originated from the Vedas, and it primarily originated from texts called Smritis, like Manusmriti and Yajnavalkya Smriti. These were not legislative laws, but scholarly works on law. The Smritis and their subsequent commentaries form the foundation of ancient Indian law. Initially, law in ancient India was customary, with no legislative statutes. The Smritis, supplemented by customs, filled the gaps where customs were weak. This approach mirrored in ancient Rome's legal system, where jurisprudence was shaped more by eminent jurists than by legislative enactments. In ancient India, not only was there tremendous development of mathematics, astronomy, medicine, grammar, philosophy, literature, etc. Just if you remember our ancient history, just if you remember astronomy or mathematics, Aryabhatta, Sushruta, Charaka, they are all great insofar as the astronomy, medicine, and philosophy is concerned. And insofar as, but there was a tremendous development of law, but for those great people, one was well versed in these aspects. This is evident from the large number of legal treatises written in ancient India. Only a very small fraction of this total legal literature survived the ravages of time, but even what has survived is very large. That means you cannot imagine what we have left. It is nothing but a ocean. Because one thing is clear, if any person will ask us, sir, you know law. Sometimes I will say, I know law. Only a drop in Arabian Sea. That's all I would say. Nothing much. History of Indian judicial system takes us to the hoary past when Manu and Brihaspati gave us Dharmashastra. Narada, the Smritis, and Kautilya, the Arthashastra. The study of these memorable books would reveal that we in ancient India had fairly well developed and sophisticated system of administration of justice compared to nowadays technology and AI. It may not match for our ancient India. That's what my personal opinion. In the early Vedic times, we do not find any reference as regards the establishment of judicial procedure. The jurisprudence of ancient India was shaped by the concept of dharma or rules of right conduct as outlined in the various manuals explained the Vedic scriptures such as Puranas and Smritis. The king had no independent authority but derived his powers from dharma, which he was expected to uphold. The distinction between a civil wrong and a criminal offense was very clear, while civil wrongs related to mainly to disputes arising over wealth. However, the concept of sin was the standard against which crime was to be defined. If you see the concept of sin, it's very difficult to get the opposite word for sin in English. But in Kannada we have Papa, Punya. But in English there is no synonymous word for sin. That is our history, that is our ancient Indian legal jurisprudence. The evolution of ancient Indian law is real. India has recorded a legal history starting from the Vedic ages. It is believed that ancient India had some sort of legal system in place even during the Bronze Age and the Indus Valley civilization. Law as a matter of religious prescriptions and philosophical discourse has an illustrious history in India. Emanating from Vedas, the Upanishads and other religious texts, it was fertile field enriched by practitioners from different Hindu philosophical schools and later by the Jains and Buddhists. Secular law in India varied widely from region to region and from ruler to ruler. Court proceedings for civil and criminal matters were essential features of many ruling dynasties of ancient India. Excellent secular court system existed under the Mauryans. It's a golden era insofar as our country is concerned, who gave importance to rigorous penal law, and the Mughals between 16th to 19th century, which preceded the current scheme of common law in India. The Mughal era between 1526 to 1857 introduced a new dimension to Indian jurisprudence by integrating Islamic law, that is Sharia law, with traditional Hindu law. The Mughal judicial system was characterized by the establishment of courts at various administrative levels and the codification of laws. The period saw a synthesis of different legal traditions, creating a more diverse and complex legal system. Understanding the ancient Indian jurisprudence is crucial for appreciating the foundation of modern Indian law. Many principles and structures from ancient texts have been adapted and codified in contemporary legal frameworks. For instance, the Indian Penal Code and Code of Civil Procedure incorporate elements from ancient legal traditions, demonstrating the enduring influence of these early legal systems. Ancient Indian jurisprudence offers a rich and nuanced understanding of law and justice. By studying its historical context and key developments, we gain insights into the ethical and philosophical underpinnings of Indian legal thought. This understanding not only enriches our knowledge of the past, but also informs the ongoing evolution of law in contemporary society. The foundations of ancient Indian jurisprudence is a complex and multifaceted subject that integrates religious doctrines, philosophical concepts, and practical governance. The legal framework evolved over millennia with significant contribution from various texts, traditions, and thinkers. To understand the foundations of ancient Indian jurisprudence, it is essential to explore the key sources and periods that shaped its development. Source of law are Shrutis, Smritis, and Achara, that is custom. Shrutis consist of 4 Vedas: Rigveda, Yajurveda, Samaveda, and Atharvaveda. Vedas chiefly dealt with religious duties, practices, and customs. First, I go to the Vedic period between 1500 to 500 BCE. The Vedic period is the earliest phase of Indian civilization and provides the foundation text for Indian jurisprudence. The 4 Vedas are primarily religious scriptures that outline rituals, hymns, and philosophical teachings. However, they also contain elements that influenced early legal norms. The key aspects of the Vedic period, that is, there are 3. One is Dharma. The concept of Dharma, central to these Vedas, refers to righteous duty or ethical conduct. It encompasses duties towards oneself, family, society, and to the universe. Dharma served as a guiding principle for behavior and was integral to the legal system. Again, I will say, Dharma served as a guiding principle for behavior. Normally, sometimes we may say that we may literate, but we may not educationalist. Education gives us how we have to behave in the society. Then only we may say that I am an educationist. Otherwise, I am only a literate, so that only I can read and write. I don't want to understand anything much about that. That's why the Dharma says that it's a principle for behavior. How to behave with other person. How I have to talk with another person. I have to live in a society where I should not interfere with the libertarian concept of any other individual in this society. Secondly, insofar as the social order is concerned, Vedic texts introduce the Varna system, characterizing society into 4 classes. Each Varna has specific duties and responsibilities, form the basis of social and legal order. Sacrifices and rituals. The performance of sacrifice, that is yajnas, and rituals was an essential aspect of Vedic life, reflecting the intervening of religious practices with legal and social obligations. If you go to the Dharma Shastras, ranging from 500 BCE to 200 CE. The Dharma Shastras represent a significant advancement in the codification of laws and ethical guidelines. These texts, written by various sages, provided comprehensive legal codes that governed personal, social, and state conduct. Manusmriti, or Law of Manu, also known as Manava Dharma Shastra, is the most important and earliest metrical work of the Dharma Shastra textual tradition of Hinduism, written by the ancient sage Manu, prescribes 10 essential rules for the observation of Dharma. One is patience, forgiveness, piety or self-control, honesty, sanctity, control of senses, reason, knowledge or learning, truthfulness, and absence of anger, that is krodha. Manu further writes non-violence, truth, non-coveting, purity of body and mind, control of senses or essence of dharma. Therefore, dharmic laws govern not only the individual but all in society. Manusmriti is commonly dated to 5th century BCE. There may be uncertainty in the period, but the Manusmriti shows the obvious influence of previous Dharma Sutras and Artha Shastras. In particular, the Manusmriti was the first to adopt the term Vyavahara Padas. The 18 titles of law or grounds for litigation make up more than 1/5 of the work and deal primarily with matters of the king, state, and judicial procedure. The Dharma classes of text were noteworthy because they did not depend on the authority of particular Vedic schools, becoming the starting point of an independent tradition that emphasized Dharma itself, not its Vedic origins. The Manusmriti recognized assault and other bodily injuries and property offences such as theft and robbery. So the concept of Dharma ruled Indian civilization from the Vedic period up to Mughal invasion. From king to his last servant, everyone was bound by Dharma. The word Dharma is derived from Dhru, to mean uphold, sustain, or nourish. The seers often use it in close association with Satya. That's what we, even in Parliament and the Honorable Supreme Court, Satya Meva Jayate. That is derived from this. It exhorts students to speak the truth and practice Dharma. Satyam Vada Dharmam Chara. According to Shankara Bhagavad-pada, Satya means speaking the truth and the Dharma means translating it, Satya, into action. In fact, Hindu law really emanated from books called the Smritis, Manusmriti, Yajnavalkya Smriti, and Smritis of Vishnu, Narada, Parashara, Apastamba, Vasishtha, Gautama, etc. These Smritis were not laws made by parliament or some legislature. They were books written by certain Sanskrit scholars in ancient times who had specialized in law. Later commentaries, that is called as Nibandhas or Tikas, were written on these Smritis. That is example, the commentary on Vijnaneshwara, who wrote a commentary called Vitakshara on the Yajnavalkya Smriti. The commentary of Jimutavana, who wrote a book called the Dayabhaga, which is not a commentary on any particular Smriti, but it's a digest of several Smritis. Nanda Pandit, whose commentary Dattaka Mimamsa deals specifically with the law of adoption. This insofar I had an occasion to read Nanda Pandit on the law of adoption in a case where whether insofar as the compassionate appointment is concerned, whether the adopted children may be considered as a family under the Karnataka rules. Then I said, when even in adoption, the one that Datta Homa is done, children giving and taking of a child is completed by virtue of a Datta Homa. Even the child will get the inherited property of the adopted parents. When such be the case, why not for compassionate appointment under the Karnataka rules? Though there is no rules providing compassionate appointment to the adopted children, I adopted the doctrine of, that is interpreted as reading in method, That is what you see, the very famous reading doctrine of the interpretation statutes. You must have read. The reading in method was adopted. Great cases Kyoto, Vallavan versus Zachilu. Can you remember there's a wonderful judgment, a great erudite judgment by Honorable Justice M. N. Venkatacharya on the 9th schedule, where doctrine in method was adopted. That insofar as while that doing that one, I read this Nanda Pandit on adoptions. Commentaries were written on because what we are seeing, what we are doing, whether we are dispensing justice, the advocates arguing the matter, these are all not new, they are old. Just we are following just not even 1% of what our ancient people have given to us. Commentaries were written on these commentaries, example Vikramaditya, which is commentary on the Mitakshara, which founded the Benares school of Mitakshara. Notable Dharma Shastras, I name few. Manusmriti is one of the most influential legal texts. Manusmriti outlines laws on family, property, criminal justice, and social behavior. It emphasizes the importance of maintaining social order through adherence to one's dharma. Yajnavalkya Smriti, this text further developed the legal principles found in Manusmriti with a focus on procedural law and the administration of justice. Narada Smriti is known for its focus on civil and criminal law. Narada Smriti provided detailed guidelines on legal procedures, evidence, and roles of judges and lawyers. Smritis in ancient India highlighted the necessity for a competent judicial system to carry out dharma-based justice, and it underlined that the king's prime duty was the administration of justice. The king was in charge of enforcing the rule of law, keeping people safe, and punishing evil doers. The key features of the Dharma Shastra is one is dharma. The central concept of dharma continued to be the guiding principle. Secondly, Vyavahara, where the section of Vyavahara dealt with procedural law, detailing the administration of justice, trial process, that is evidentiary part, and the roles of judicial officers, how a judge should be. And the third one is Prayasthita. This aspect dealt with offences and punishments, prescribing atonements for various offences. Types of ancient Indian courts. Katyayana Smriti divides the courts into 6 categories based on their rank. They are as follows. Firstly, Sula, that is family councils or groups. A group of elderly people who are educated members of a family take care of conflicts inside the family or among families of similar background. The Shri, that is the trade and professional council. An assembly of old and knowledgeable people who are recognized as unbiased among group of traders, professionals, and craftsmen to arbitrate conflicts. Thirdly, the Ghana, that is village assembly. This was a huge gathering of village or Gramal elders who were regarded as knowledgeable, unbiased, and trustworthy by the people of the region. Fourthly, Adhikruta, court appointed by the king. These are all the courts recognized by the king to serve justice, with justices who are highly trained in the Shastras and Smritis. This sort of court came in a variety of forms depending on its jurisdiction. They are Pratisthita, which was founded in a certain village or a town, and Apratishta was a movable court that would convene in a given location to try a specific matter as summoned by the king, and Mudrita was a higher level court that had authority to use the royal seal. This is what we have the provisions in Legal Services Authority today, 1987 Act. That means these are all not new. Nowadays statutes are enactments. Next one is that is King's Court. This was the kingdom's highest court of law. The king himself presided over it. To serve and support the king, there was a chief justice named Pradvikva and a group of judges named as Sabhyas. Sabhyar. That means judges will be Sabhyar always. Nrupa, king himself. The king was the supreme authority in the legal judicial adjudication process, and he was governed by dharma precepts that he could not contradict. This is what we know as Article 13 in the Constitution of India. That is the rule of law principles. That is what we call it as, if you look at the different schools in law also, whether it's a positivism, Austin says, or the Kelson's pure theory of law, where you say that the grand norm, a pyramidal structure is always the above, and we are all the organs of the democracy, that is legislature, executive or judiciary, we derive our powers from the Constitution. Constitution is the grand norm. It is the grand norm. That's what it says in Kelson's pure theory of law. Nextly, the jurisdiction of the courts. With the exception of a violent offense, Kula, Shri, and Ghana may try all civil and criminal cases. A court named Adhikruta, constituted by the king, will hear instances related to violence. The Sasita, that is the king courts, will determine on corporal punishments, but the king holds the final power and finalize them. That is the pardoning power of the president, or remissions given by His Excellency Governor. A Kula ruling can be examined by the Shri, and a Shri decision can be examined by Ghana. This hierarchy of courts. Similarly, the Adhikruta courts can examine a Ghana's judgment, which follows a hierarchy of courts. That means, if there is hierarchy of courts, one thing is very clear, dear friends. Ultimately, the justice will be given to the party when you have suffered a legal injury. Ancient writers have outlined a hierarchical system of courts as having existed in the distant past. The accurate framework that achieved cannot be conclusively proven with any correctness. But afterward, writings of writers like Narada, Brihaspati, and others appears to suggest that usual courts must have existed on a substantial level. Throughout the ancient Indian period, the hierarchy of courts was said to exist, with certain aspects of authoritarian hierarchy of appellate power over the courts of courts bidding. The judges of the courts. The ancient scriptures include information about the method of recruitment and competence of the respective judges. Yajnavalkya advises the sovereign to choose as evaluators of his court individuals who are well versed in the professional legal literature, honest and behaviorally capable of absolute impartiality between a friend and an enemy. The Rajadharma advises the king to choose judges who possess specific characteristics of quality inbuilt in them. There are as follows. A judge should be well versed in Vyavahar, that is, laws governing court process. That means conducting court proceedings fairly. So conducting a court proceedings fairly means nothing but a judge is sitting in just like a seat of Vikramaditya, administrating justice, without looking into who had appeared, what is the matter, just looking into the text or the paper and to decide the matter on merits. That's all. Nextly, the dharma, that is legislation on all subjects. Thirdly, Bhavushushruta, that is deep researcher. Every day we are student of law. Every day we have to learn many things. New concepts will come. New doctrinal will come. If any case will come up to the court, then normally we decide the matter on what the law is. What the law is. Because we have to decide in accordance with law. That's what we have taken both. That's what the deep, a judge must be a deep researcher. Next, fourthly, Pramanjana, we are well intimately knowledgeable in the rules of evidence. Rules of evidence means whether the principles of natural justice complied with our law. See, these are all the things we may not find in a substantial law. These are all the things we cannot find in substantial law. Take for an example, these are all the well intimate knowledge of rules of evidence. Will, even if the decision may be correct, but the decision process, whether there is any infirmities there or not, even that has to be looked into by the learned judge. Nextly, a responsible and law-abiding citizen. That's what court must require. Who fully studied the Vedas and Tarka, that is logical reasoning. Katyayana had some further requirements for the temperament of a judge, stating that a king should choose a judge who is not harsh or cruel, delightful, kind, bright, and active, but not arrogant. According to the ancient scriptures, judges must be unbiased, autonomous, and courageous, with a certain degree of bravery. The Smritis and Shastras establish judges' lofty and honorable position in the administration of justice in the society. Their courage, neutrality, and integrity, even when their conclusions go against the intentions of the king, are invaluable and a lesson to us. This concept of judicial freedom and independence was also obligatory on the king, since the supremacy of Dharma was almighty, and law derives its legitimacy from the trust of the populace and the king in Dharma. In accordance with the statement, law is the king of kings. As can be seen, the Smritis established a clear and strong framework for a competent, independent authority of the judiciary. Each Smriti underlines the predominance of judicial honesty. According to Shukra Niti Sara, the king selected judges should be wise, of excellent character and temperament, gentle in speech, impartial to friend or adversary, truthful, knowledgeable in law, active, free from rage, greed, and evil desire, and factually correct. Even insofar as the concept of lawyers is concerned, our Dharma Shastra says that in ancient times the notion of lawyers appearing for the parties and assisting court was used. A niyogi was an individual who was well experienced and knowledgeable in law and was appointed by a party to a lawsuit, that is, lawyer. Shukra Niti Sara indicates that the person authorized to represent a party in court was entitled to collect his fee to the extent of 1/16th, 1/20th, 1/40th, or 1/60th of the suit claim, and the payment should be indirectly proportional to the lawsuit. Because it is the duty of the lawyer to assist the court to arrive at a just conclusion, not necessarily that he has to defend his clients. Maybe he has taken fee and he has to defend his client, but ultimately he has to assist the court to arrive at what should have been to be done in a particular case, whether the judgment will be made, because unless if any judgments will be rendered by any judges, of course, ultimately the role of a judge, how he assists, it makes a lot of difference. The court proceedings are concerned. In the ancient time, the courts followed a well-defined procedural framework. Anyone who has been harmed by the actions of others may file a pratisthana, today what we call it as complaint under section 200 of CRPC. Pratisthana to the court. Prativadin was known as to be the defendant and Vadin as the plaintiff. Dharmakosha provides a description of the plaint as being succinct in words, abundant in meaning, clear, free of immaterial facts, empty of unsuitable reasoning and arguments, accurate and not logical, inconsistent, and it should include a purposeful request directed at the defendant of a respective case. This is what we have seen in Order 6, 7, and 8 of CPC. Because we have to say only the material facts, not all the facts. The person who has read the plaint may come has arrived at a conclusion that what the case, how he has the plaintiff has agreed. In order to, because even when you draft a written statement, if anything is there, how to make the averments made in the plaint to see to that it will be easier for the judge to frame the issues under Order 40. Because meeting the plaint and the written statement ultimately resulting in framing an issue by the court, That's what insofar as the court proceedings is concerned. Particularly the Order 6 Rule 4, please read it, dear friends, where it makes a lot of, because drafting is a skill, it's an art. Just even if, take for an example, if the arguing counsel may not argue the matter in a manner in which a senior would appreciate him, but one thing, if the judge, if we see the plaint or the written statement or the pleadings as a whole, it is good for the learned judge to decide the matter fairly and to see to that there should not be injustice to the parties. The court fees were also levied, with the judgment debtor obligated to pay 5% of the lawsuit amount and a plaintiff obligated to pay an equivalent amount. That's what we say, Source Valuation Act, 1957. The trial was carried out in compliance with the Dharma Shastras and in any way that guaranteed the litigants and the public's trust in the court and the judiciary. The burden of evidence and proof of placed on the individual who claims the wrongdoing or the so-called offense. The parties have the option of producing the witness. That is always section 101 of Evidence Act. Onus always lies on the plaintiff to prove his case. When it will be shifted to the defendant or not, will be looked into only based on the case in which put forth by the litigants. The verdict was titled Jayapatra, that is a judgment. Since one side was to win the lawsuit, the Jayapatra should include a simple note of the plaintiff and written statement. They show that how we have to write the judgment. Collaboration presented by the parties, that is arguments. Framing and discussion of the issue. What is the issue to be decided in a given matter? Recognition of sides' assertions. What are the arguments? What are the arguments advanced by the counsels? Implementation of law. How you have to correlate the fact into the law. Then distinct viewpoints of the judges. That is what we call it precedents. If there is any precedent is there on the point, whether it has to be followed or not. If any, take for an example, if any judgment delivered by the equal coordinate bench taken a different point of view, how I have to meet those points. Then ultimate decision, that is the judgment. We call it as a decree and the court seal, because it is seal of the court. The judge should act in accordance with fairness, equality, and moral conscience while pronouncing the verdict. The punishments, even now we come to punishments. The punishments were divided into several categories. First one is Vagdanda, that is what we call it as reprimand. Next, Digdanda, condemnation. Next, Dana penalty, imposing of cost. Then Angacheda, retaliation. Then Vadadanda, capital punishment. These are all the 5 punishments were there in the Dharma Shastras. According to Mahabharata, punishment preserves Dharma, Artha, and Kama. Dandaniti is very well recognized in Shastras, and it was seen to be significant that even without the king and his authority to chastise offenders, ordinary people would have constantly been plagued by greed, insecurity, and threats of life and property. It is uncommon to find people who are constantly pristine in all parts of their lives, and a deterrent has always been required to correct the offender. Next we come to Arthashastra. The Arthashastra attributed to Kautilya, that is Chanakya, marks a significant shift towards a more secular and pragmatic approach to governance and law. Written during the Maurya Empire, it is a comprehensive treatise on statecraft, economic policy, and military strategy. The notable contributions of Arthashastra is that the role of king. The Arthashastra emphasized the king's duty to uphold justice and maintain law and order. It detailed the responsibility of a ruler in ensuring the welfare of the state. Secondly, legal procedures. The text provided meticulously description of judicial procedures, types of evidence, and the administration of punishment. Insofar as the Arthashastra is concerned, for the first time we can see the element of examination chief, cross-examination, and re-examination. These are all the three aspects we can see in Arthashastra. Insofar as economic laws is concerned, it included regulations on trade, commerce, and market practices, reflecting the integration of economic management with legal governance. Next, I come to the influence of Buddhism and Jainism. The emergence of Buddhism and Jainism in the 16th century BC brought new ethical perspective into the legal framework. Both religions emphasized non-violence, that is ahimsa, compassion, and ethical conduct, influencing laws related to social welfare and justice. Insofar as the main contribution of the Buddhism is concerned, Ashoka's edicts, Emperor Ashoka, a devout Buddhist, implemented a significant legal and administrative reforms. His edicts, inscribed on pillars and rocks, emphasized justice, non-violence, and the welfare of all beings. Ashoka's policies promoted religious tolerance and human governance, what we see in Article 25 to 30 of the Indian Constitution. Insofar as the Jain contribution is concerned, firstly, ahimsa, Jainism's strict adherence to non-violence influenced legal thought, particularly in areas related to animal rights and environmental conservation. Today, what we see the environmental, whether it's air or water. Or even take for nowadays, just a week before a judgment rendered by the Honorable Chief Justice Dr. Chandrachud on the related to climate change, how the environmental law has to be changed or it has to be co-op with the laws which are existing today. Next is the ethical conduct. Jain principles of honesty, non-possessiveness, and asceticism contributed to the development of laws that encourage ethical living and social responsibility. Now we come to the great empire of Maurya, where I personally like this dynasty. That's the dynasty where it changed the facet of Indian civilization. The Mauryan Empire, under the leadership of Chandragupta Maurya, and later Ashoka, witnessed significant legal and administrative reforms. Chandragupta Maurya was the first ruler of India, opened the gateway for egalitarian society. That's what we are seeing in Article 14 of the Indian Constitution. Because when the concepts relating to the providing reservation, the Article 15 class 4 and 16 class 4 of the Indian Constitution during the Indirashwara's case, if you read the judgment rendered by the Honorable Justice BP Jeevan Reddy, the erudite judgment, where you say that reservation is a concept of the melting point. See, don't say that it's a discrimination, it's a protective discrimination. When you are protecting the discrimination, you are bound to provide those aspects in the Constitution itself. Because, as Granville Austin says, the social justice is the signature tune of Indian Constitution. Because why I am saying all these things, these are all the things insofar as where our founding fathers are thoroughly read while framing our Constitution. What a great people. If you read the book on Alladi Krishna Swami, published by the Bharatiya Vidya Bhavan, you may come across what kind of the great jurists we have even during 1950s and 60s. The Chandragupta's governance, if I mention, under the guidance of Kautilya, Chandragupta established a centralized administrative system with a well-defined legal structure. The Arthashastra played a crucial role in shaping the governance and legal practices of the empire. Next is for Ashoka's reforms. After his conversion to Buddhism, Ashoka implemented policies that emphasized justice, compassion, and social welfare. He propagates religious tolerance, non-violence, and human treatment of all beings, setting a precedent for ethical governance. The Gupta period during 320 to 520 CE, often referred to as the Golden Age of India, saw further refinement of the legal and judicial system. Insofar as legal codification is concerned during the Gupta period, where the Gupta rulers codified laws and made significant contribution to administration of justice. The concept of Dandaniti, that is the science of punishment, was further elaborated, reflecting an advanced understanding of legal principles. In this regard, I request appeal to one of the articles written by Honorable Justice K.T. Thomas on criminal law jurisprudence in India. I think I have forgotten when it is published. It is there in SEC. Please appeal to the people. See to the please read how the punishment, the concept of punishment was evolved from the Dharma Shastra till the enactment of 1950. That is Constitution as people. Insofar as judicial system is concerned, became more organized with clear distinction between civil and criminal law. Courts were established at various administrative levels to ensure the efficient administration of justice. Insofar as Gupta period is concerned, though there is the administrative courts, we call normally, if you look at the jurisprudence, that administrative was started in France. But of course, that was there even in the Gupta period in India itself, long period. It's not new. We may not say that it's evolved in French Revolution after the 5 French Revolution, where the broad administrative was constituted by in France. But even in India during Gupta period we had it. Insofar as the Mughal era is concerned, 1526 to 1857, that's first freedom battle. The Mughal Empire introduced a synthesis of Islamic and Hindu legal traditions, creating more diverse and complex legal system. Integration of Sharia. The Mughal rulers integrated Islamic law, Sharia, with the traditional Hindu law, reflecting the multicultural nature of the empire. This integration influenced various aspects of law, including family law, criminal justice, and property rights. Judicial reforms during Mughal era was the Mughal judicial system was characterized by the establishment of courts at different administrative levels, codification of laws, and the appointment of judicial officers. Now I come to British period. A great jurist, Bentham, was regarded as the father of jurisprudence and was the first one to analyze what is law. Natural law theory says law is a dictate of reason. This you know very well. This Solvent's 14th edition of Fiscal Law. Regulating Act 1773 was established. The Supreme Court of Judicature at Calcutta. With this, dear friends, what I would say, from early Dharma Shastra, Narada's 58 till British period and after the other enactment is made. If you look at the provisions under the Indian Constitution, though we may say that most of the things we borrowed, part 3 we have borrowed from the US parliamentary system and rule of law principle we borrowed from the UK, where it is unwritten, but our constitution is a written constitution and our government is a limited government. And we borrowed part 4 of the Indian constitution from Irish, insofar as the emergency powers from France. And like that, many of the provisions where we may say that we borrowed, but how those provisions, not only that they have borrowed our founding fathers, how it was adopted to the 33 crores people during 1950. There were 33 crores then. Because by that time, the moment we have got freedom, the rule, it is very difficult for the then after 1947, everything economic problem. The agriculture is the backbone of our country. It is also very difficult because you have to make certain scientific change in the agriculture. And food itself is a great problem then. I think if you speak with your father or grandfather in your family, you will come to know all these things. Because they, even as far as the grains were be given in not regularly, it's very difficult to even get a food then. How our founding fathers have had this in their mind and have this insofar as the past what they have experienced. And they also felt what is to be needed and given to this country. Because this is the, if you read the work on the great Venegal Narasimha Rao, who is the constitutional advisor to the Constituent Assembly, under the guidance of the architect of our constitution, the Ambedkar ji. That's what he said. As long as we vote to this constitution, we get everything. Nothing new. No amendments are required. Because ours is the biggest democracy in our country, in the world. So we are, even today, if you look at, we are 140 people. This country is given food at least for 2 meals for 140 people. What kind of resource we have in this country? See, that should be there in our mind always. With this, I will come to conclusion. In a nutshell, I may conclude that dispensing justice and awarding compensation was one of the attributes of sovereignty. Sovereignty means, that is what we have positive in Hastings, say that the law is given by a sovereign through commandment to the subjects. To preserve dharma, which is an essential feature of ancient Indian jurisprudence, talks about righteousness and duty, both fundamental rights and fundamental duties. Dharma implies every person has a responsibility to other person and right to exist. This is what we call it as, if you look at the Lord Atkin judgment in 1912 in Donagh versus Stevenson, doctrine of neighbor principle. Doctrine of neighbor principle. Donagh versus, that is ginger beer case. That's what we have called it and borrowed, enacted in 1986 Consumer Protection. We must be accountable to our neighbor. Consumers must be accountable, the manufacturer is accountable to the consumer. That is what we have seen, even that was existed in Dharma principles. Principles of interpretation were developed in a high degree of perception. The first principle of law is to do good to others, to promote it by avoiding evil in the society. Synonymous with natural law theory. That's a law is a dictate of reason. The study of law in jurisprudence is not about any particular statute or a rule, but in general, studying concepts and its principles as well as the philosophies underlying those principles. Indian jurisprudence seeks to balance traditional values with modernity, individual rights with social welfare, as well as legal certainty with adaptability. That's what we have. Article 368 provides for amendment. The study of ancient Indian jurisprudence offers valuable insights into the evolution of legal thought and practice. By understanding the historical context and development of these early legal systems, we can appreciate the foundations upon which the modern Indian law is built. Take for an example, if any treaty is to be entered into by any other country with India or any other country as a whole, whether it's a contract or agreement or something, firstly the countrymen will look into who are the great jurists in this country. Because if there is any breach to claim compensation or anything, or to approach the Hague Court, then what are the great legal crimes in a particular country? Because if the legal system, the legal system is good in a country, then normally the relation with even foreign affairs, the policy will be always good. Moreover, we can appreciate the foundation upon which modern Indian law is built. Moreover, acknowledging both the strengths and shortcomings of ancient jurisprudence allows us to create a more just and equitable legal system in recognition of rule of law principles runs through the golden thread of provisions contained in the Indian Constitution. A distinguishing aspect of ancient Indian law was that it was secular in nature and founded on Dharma principle. This is very important. This, in fact, I got it from Justice Ramajo's book. The distinguished aspect of the ancient Indian law was that it was secular in nature, but founded on the Dharma principle. You must be a secular as well as follow the rule of law principle. That is the natural law theory. At the time, the Indian population was used to notion of living under the law and had court means to deal with civil and criminal issues. Ancient India had the highest possible level of antiquity in terms of ability, acquiring knowledge, honesty, objectivity, and judicial independence. And these benchmarks have not been outperformed till today. The highly developed legal framework and judiciary which are firmly based on the Dharma concept, as well as the devout nature of Indian people who adhere to the legal system, have enabled India to lead a prosperous judicial system. For a civilization to progress, it requires a supportive system of peaceful living, which necessitates a proper and graft law and order system, as well as an active judiciary. Having narrated the development of law in India from its inception, I may conclude that ancient Indian jurisprudence met all the prerequisites of an egalitarian society, that is the government, which should work for the societal interest, following the rule of law principles. Dear friends, if you look at our Dharma Shastra and applying to the principle, one is where there is a dharma, there is a righteousness, there is a duty. If the governance in the state, maybe it is the legislature, judiciary, or the executive, if they adhere to these principles, then one can say that Sarve Jano Sukhino Bhavantu. If you light a lamp for somebody, it will also brighten your path. If you, in this regard, in Hinduism is considered, please read the judgment rendered by the Honorable Justice J.S. Verma in Manohar Joshi election case, where the Supreme Court say that Hinduism is not confined to strict Hindu practices. He said, Hinduism is not confined to strict Hindu practices, unrelated to the culture and ethos of people of India. Because that's what we have seen in Sheik Latheef's judgment. The Honorable Supreme Court say that people are at the back of the Constitution. The people's pulse we can see in the preambular objects, what we have seen in the Indian Constitution. He said, Honorable Justice J.S. Verma said that the Hinduism depicts the way of life of Indian people. When you interpret a law, what I gathered from the Dharma Shastra, if you just while interpreting the law, you must look into not only the text, but the context in which the law has been made. Text and context must be looked into together to arrive at a justness. And this, I conclude, dear friends, this country has given everything for us. And the oneness should be there in our mind. And just you believe that when our Constitution was framed and the Ambedkar ji, he came out from before the promulgation from the Parliament House. A law student from Cochin University, he was waiting for Ambedkar ji. He asked Ambedkar ji, sir, you have given a very great constitution for us. Because by that time there is 5 French revolutions were there, constitution was there. How far this Indian constitution today you have made will be proceeded, will be adhered. Then the Ambedkar ji say that it is not the constitution. How long we preserve this constitution, how long we follow the principles. Even how we have seen, because our founding fathers, they are all, can't imagine, they are nothing but, of course we are not heard about Shri is a sage. According to me, our constitutional, his father's framework was embedded, they are nothing but sages for us. They are sages, they are great rishis for us. They have given very great constitution for us. When they have given this constitution, they were never, because today even after 75 years, nearly of our independence, 140 people we are living. This constitution is preserved like anything. Preserved by like anything, not by the constitution itself, by the people. By the people. Because, as Abraham Lincoln says, the law should be for the people, by the people, of the people. In just a lighter way. T.P. Kailasam, you heard about him. He said once, if everything is going well, right, democracy will be survived. If the rulers are not good, if the governance in the state is not good, T.P. Kalam said that democracy is of the people, OFF. Democracy is for the people, FAR. And of the people, for the people, and by the people. You can buy the people. This is what TP Kailasan says. Because as long as you adhere to the constitution, as long as you governance in the state is good, nothing will. Because this constitution, of course, we are not seeing the great founding fathers, all of us. At least we are seeing a great patriotic, the Abdul Kalam. Once he said, we need not do great things in this country. ನಾವೇನು ಈ ದೇಶಕ್ಕೆ ದೊಡ್ಡದೇನು ಮಾಡಬೇಕಾಗಿದೆ. I don't want to become a soldier, ಅಥವಾ I don't become a chief minister or a chief justice or a chief secretary of the country. We need not ದೊಡ್ಡದೇನು ಬೇಕಾಗಿಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು, ದಾರಿಯಲ್ಲಿ ಹೋಗ್ಬೇಕಾದ್ರೆ ಮುಳ್ಳನ್ನು ತೆಗೆದು ಸೈಡ್ಗೆ ಇಟ್ಟರೆ ಸಾಕು. That's what we can do. That is not small thing is real. This is what the Abdul Kalam ji said. So this country has given everything for us, dear friends. Now you are opening your eyes in law courts. My humble request for all of you, please always uphold the law and the constitution. And this constitution is not just a drafted one. It is nothing but a document, like what we find for every solution we find problem solution. For every problem we find solution in Mahabharata, Ramayana, and Bhagavad Gita. The next fourth one is our constitution according to it. We find everything in this constitution. So do good for this country. And in this regard, I shall be very grateful to the Bangalore University and also the Vijnaneshwara Pratisthana Trust, Marathur, Kalaburgi district, for having given an opportunity to share my thoughts relating to the Dharma Shastras and so far as the ancient Indian jurisprudence is concerned. Thank you.
We most profusely thank Honorable Justice E.S. Indiresh for his discourse, which was enlightening and thought-provoking indeed. Sir, we thank you very much. Now, may I invite our own Senior Professor, Dr. V. Sudesh, to address the gathering, presidential address, followed by the formal vote of thanks. Sir, please.
Ellirigu namaskara. I stand before you on behalf of Bangalore University, University Law College and Department of Studies in Law, and also on behalf of Vijnaneshwara Pratisthana Trust, Marathur district, Kalaburgi. Honorable Justice Shri E.S. Indiresh, Judge High Court of Karnataka, members of my teaching faculty, the members representing the Vijnaneshwara Pratisthana Trust, Marathur district, Kalaburgi, guest faculty, research scholars, students of this college. Indeed, today when I was listening to Justice E.S. Indiresh sir, I remembered those days when we were guest faculties in one of the private colleges. I mean, in his presentation, the essence of the teacher has come forward. A teacher is always a teacher, though he is now in the position of a justice, a judge in the High Court of Karnataka, but the essence of teaching is there. To teach the same topic, probably I would have taken 4 or 5 hours in the regular classroom. And in fact, my LLM students right now are learning advanced jurisprudence course. I have not yet touched upon the Dharma as law in the Indian context, but an essence of that today is understood by all our students. Thank you, sir. It was a wonderful, holistic presentation. Especially it opened the minds of young law students. We have a mix of the first and the second year students, also the outgoing batch of students. Your speech was peppered by several historical quotes on how ancient Indian jurisprudence developed. You were right, sir, when you said today what we have, the modern law, is a blend of the modern and the old thinking. Yes, sir. Unlike the modern trend of the legislators giving us the law, those days it was the experts, eminent jurists who gave us the law. The concept of justice, governance, social, ethical context of law is very well illustrated. From Vedas to the Smritis to the scholarly works, you have elaborated on how each aspect of the governance of life is written and was perpetuated on. Very rightly said, despite the ravages of time, some part of the ancient Indian jurisprudence is still survived. And this some part is still like an ocean. In fact, today's your presentation itself, I don't know, it was very difficult, but you have encapsulated it within 45 minutes is a great, it's only a teacher can do, a teacher or a judge can do. Because a judge after several rounds of hearing, his judgment is very brief, relief. So a mix of judge and the teacher has brought out your speech. Yes, sir. Very right. Notwithstanding the information technology and the artificial intelligence that we have, we cannot, surely not, forget the contribution of ancient Indian legal thought. Papa Punya. We thought about this as a childhood, as a small child. ಇದು ಮಾಡಬೇಡಿ, ಇದು ಪಾಪದ ಕೆಲಸ ಮಾಡಬೇಡಿ, ಪುಣ್ಯದ ಕೆಲಸ ಮಾಡಿ. No equivalence in the English jurisprudence, the Western jurisprudence. Sir, you rightly pointed out, and your personal liking for the Mauryan rule, the Mauryan Empire, the golden period, as you said, the essence of dharma, the grandam in the present context and the ancient context, the spread of Buddhism and Jainism and its impact on ancient Indian legal jurisprudence, the spread of religious tolerance, welfareism through Buddhism and Jainism was very well illustrated. There's so many things, of course. Now, I don't want to repeat what the judge himself has presented. Luckily for all of you, unlike those previous days where the lectures of Professor C.K. and Raja, Professor Rajappa, Professor Ishwar, but our own teacher, Professor Coutinho, could not be recorded unless it was printed and supplied. So today, your lecture is gone live on YouTube. So some of my student friends who have been given this task of writing the highlights, if you have missed out something, you can go back and visit the Bangalore University Law College website and re-hear it once again, because he brought out everything for all those now going out of this college in another 1 or 2 months. What should be, how it should be drafted, what should be pleaded, what is your role as an advocate, very important, because right now we are undergoing a course on professional ethics. Yes, sir, rightly said. Maybe a client has engaged you, maybe you have taken some money to speak on your behalf, on his behalf in the court, but the whole idea is that you must assist the court, you must assist the judge in bringing out the truth. Very right, sir. Sir, indeed it was a very wonderful lecture. I personally wanted to invite sir for the inauguration of the moot court competition, but then our great friend from Vijnaneshwara Trust hijacked that. He said, no sir, we'll invite him for this function because the moot court is happening the next week. Anyhow, sir, I wish and we all pray that you come to this college very often and give us lecture on various issues confronting the youngsters, especially on artificial intelligence, information technology, etc. Thank you so much, sir, from the bottom of my heart. I owe my thanks to the members of the Vijnaneshwara Pratisthana trustees who personally come here, Shri M. Lakshmirana sir, IAS, former additional secretary to CM, Shri Sudesh D. Bulbule sir, Professor Kotresh, our former registrar, Deshpande sir, and all other members. I thank our alumni friends, seniors of this college, leading advocates from the High Court of Karnataka, Sridhar Prabhu and Vikram Bharge for having joined this important discourse today. My thanks are also due to the coordinator of this program, Professor Dr. Jyothi Vishwanath, senior colleague, Professor Dr. Indiresh sir, Professor Satish Gowda sir, and Professor Dr. Chandrakanti madam. Thanks to each one of you for having very patiently listened. I was insisting yesterday we had a ethnic day celebration, sir, you know, in colleges. And they were all in a festive mood, dressed up colorfully, and they did not want to change their mood. I said, no, this is worth it. And all of them have come dressed up for this occasion. Thank you, each one of you. Thank you so much. I request first of all, Honorable Justice Indiresh sir to give an opportunity for a group photograph with my faculty members. and then the trustees. Thank you so much. Thank you, everyone. Be seated until the judge we exit the hall. Thank you so much.